This is 33 pages long, so I will just take breaks and publish them separately. So, claimant, myself, respondent, Vinex Limited, heard at Croydon by video on 15th of September 2025 before Employment Judge Fowl. Appearances, claimant, no appearance. Well, I wasn't invited. Respondent, Mr. James Shakeshaft, Director. I requested multiple times for my hearing to be held remotely, and these requests were repeatedly refused. The respondent, by contrast, attended remotely via video without issue. I was never provided access details to attend my own hearing. This demonstrates clear and manifest bias toward the respondent by Employment Judge Fowl. The claim is struck out in its entirety under Rule 38(1)(b) of the Employment Tribunal Rules of Procedure on the basis that the manner in which the claimant has conducted proceedings has been scandalous, unreasonable, or vexatious. The term scandalous, unreasonable, or vexatious is being misapplied. The respondent orchestrated retaliatory arrests, harassment, intimidation, and national press defamation against me. Those actions, not my conduct, meet the criteria for being scandalous and vexatious. Denying me the ability to participate while the respondent is fully accommodated subverts justice and wrongly portrays me as the aggressor. 2. Further, or alternatively, the claims are dismissed under Rule 47 on the basis that the claimant has failed to attend or be represented at this hearing. I was refused participation in my own hearing and had no option to attend or be represented. Rule 47(2) requires the tribunal to consider any explanations for absence. My repeated documented requests for remote access were ignored, while the respondent attended remotely without issue. This constitutes procedural unfairness and manifest bias, as the tribunal effectively privileged the respondent's convenience over my right to participate. Reasons. Judge Fowl says, 1. Most unusually, this case is being struck out without a final hearing. It follows an order made by Employment Judge Ramsden at a preliminary hearing on the 4th of June 2025 that such an order was being considered. Since this is a public document, I will summarise the relevant background to that order. The claim was brought on the 22nd of June 2024. It is primarily a claim of constructive dismissal and sex discrimination, although the relevant boxes on the claim form for whistleblowing and discrimination on grounds of age are also ticked, together with boxes for a statutory redundancy payment, notice pay, holiday pay, unlawful deduction from wages, and other payments. Employment Judge Fowl's summary omits the claim of bullying, which forms a central part of my case. The reference to age discrimination is highly relevant. Jamie Shakeshaft, who is significantly younger and markedly less experienced than me, was nonetheless promoted, while my proven commercial experience and top performance were repeatedly ignored. This appears to be nepotism and discrimination based on subjective bias rather than merit. Additionally, I was forced to use annual leave to cover sickness and was denied new business bonuses on multiple occasions, constituting unlawful deductions from wages and detriment under the Equality Act 2010, Sections 19 and 39, Prohibition of Discrimination in Employment, and Protection from Harassment Act 1997, relating to bullying and harassment. These omissions by the tribunal indicate an incomplete and potentially biased assessment of the full scope of my claim. Under Article 6 of the European Convention on Human Rights, ECHR, I am entitled to a fair hearing, which includes full recognition of all claims brought before the tribunal. Failure to acknowledge the bullying aspect, which is well evidenced, undermines this right and constitutes procedural unfairness. It followed Ms. Ashwell's resignation on the 3rd of June 2024 after 3 years' service as a portfolio manager for the respondent, which is a company in Horsham promoting financial investments in wine. According to the claim form, despite being the top performer, Ms. Ashwell was repeatedly overlooked for promotion. In fact, 2 other men, whom she says did not perform nearly as well, were promoted to senior portfolio manager. She then became demotivated and was, she says, unfairly put on a performance review process. The tribunal's summary here merely restates my claim without engaging with the discriminatory and retaliatory elements of these actions. Being overlooked for promotion despite top performance while less qualified male colleagues were promoted constitutes sex discrimination and potentially age discrimination under the Equality Act 2010, Sections 13 and 19, Prohibition of Discrimination in Employment and Unfair Treatment. Furthermore, the imposition of a performance review process in response to my complaints and proven results may constitute detriment and victimisation under Section 27 of the Equality Act 2010, as it appears to have been a punitive measure for raising grievances regarding unfair promotion practices. This demonstrates a pattern of systemic bias and harassment, which the Tribunal is obliged to consider fully under Employment Tribunal Rules of Procedure Rule 3, overriding objective dealing with cases justly. By failing to analyse these aspects, the Tribunal has ignored substantive evidence of discriminatory and retaliatory conduct, undermining the fairness of its summary and the wider process.